senior judges from various other high courts who are also gracing this occasion, learned justices and judicial officers and legal officers from various jurisdictions, Commonwealth countries who are participating in this event, Sri Rajendra Prasad, learned Advocate General Rajasthan, Dr. Nandini Gauri, General Secretary of Nivaran, Registrar General and other officers of the Rajasthan High Court, Member Secretary and other officers of the State Legal Service Authority, very distinguished senior advocates from the Supreme Court Bar and from the Rajasthan High Court Bar, members of the legal fraternity, learned mediators, distinguished delegates, friends from media, my dear students, ladies and gentlemen. Very good morning to all of you. Speaking on a subject which is very close to my own convictions and that I hold to be the very future of dispute resolution not only in India but beyond its shores, is extremely satisfying. It's a privilege to expound upon it before an assembly which is so adept at the craft of drawing estranged parties back to a common table. I have had the honor of delivering innumerable addresses upon mediation, its many faces, its advantages, and the case for embracing it with a greater conviction. Yet, I confess with no small candor that I never truly tire of this subject. If anything, it re-energizes me every time, and gatherings such as this one stand as a testament to that, is mediation only. Mediation remains a discipline deserving of far deeper study, one that discovers almost daily fresh and more compelling avenues of application. All of you have heard many a times that old story of the orange quarrel between two sisters. The fact was that one wanted only peel, the other was keen in the juice, but the mother didn't know, and in her anxiety to buy peace for both of them, she cut the orange into two pieces, thinking that both will be happy. But that decision led to unhappiness and dissatisfaction among both the sisters. Because both sisters had quarreled over the whole orange, when each in truth had desired an entirely different half of it. Had anyone paused to ask why each daughter wanted the orange, rather than merely how much of it she wished to claim, the mother could have given each daughter the whole of what she truly needed, and there would have been nothing left to divide, left alone to quarrel over. I return to this story so often because it captures in a single image what several volumes of negotiation theory labor across chapters to argue. And what it says, that disputes are so frequently waged over positions, over the visible shape of the orange, when the truer and more abiding settlement lies concealed in the interest beneath, in the reasons the fruit mattered in the first place. So my dear friends, this metaphor very clearly explains the distinction that I wish to draw. It is that litigation is built to adjudicate positions. It asks who owns the orange and answer with a verdict, a half each, maybe an injunction or a decree. Mediation, on the other hand, poses an altogether different question. It asks what each party truly needs. And time and again it discovers that what happened an irreconcilable conflict was never one of substance at all, but merely one of assumption. This parable carries no ancient pedigree, and I make no claim that it does. points to something far older than itself. The instinct to ask why a claim is made rather than resting content with the claim alone. That very instinct, I will show, runs deep through our own civilization's approach to resolving disputes. Yesterday, in the inaugural session, it was very aptly highlighted that mediation is something in the veins and in the history of India. If you remember India, then you start remembering the Ramayana, the Mahabharata, and beyond our historical stories. And every story tells a new dimension of mediation that I need not to repeat. It was very well, thoughtfully referred yesterday in the inaugural address. But let me tell you, out of this very history, a brief reference to Kautilya Arthashastra. That was, of course, centuries later. Kautilya prescribes 4 modes of governance and rule of law. And in Hindi, he called them the Daam, Bhed 3. He prescribed 4th is the ultimate verdict of the king. Daam, and Bhed. So what is Daam? Daam is incentives or price. Saam, Daam, and Bhed 4. So the Saam is persuasion or conciliation. Daam was incentives or price. Dand was punishment or force. And Bhed was division or exploitation. That was the rule for the king, that divided rule for the king. So when Arthashastra, Kautilya, one of the best philosophers I have ever read in the history, he talks of the first option he gives of Saam, persuasion or conciliation. So basically the principle of mediation is originating from that very philosophy which really ultimately led to the laying down of the codified principles of governance, and governance in which the rule of law plays a vital role. You go to another history after that, hundreds of years after Kautilya, then came another philosophy, that hierarchy of adjudicating bodies, Kula, Shreni and Puga. And thereafter the king's own verdict. Again 4 principles, and the first principle again talks of sitting together, resolving your disputes among yourselves. And post in the previous century, before and after independence, all of us read about Rashtrapita Mahatma Gandhi reflecting upon his own years at the bar and ultimately confessing that the most satisfying experience as a lawyer was when he could mediate between the parties or could contribute in an amicable settlement between the parties. What we glean from this is that long before mediation, as rightly pointed out, acquired a statute in India in 2023 and maybe in other jurisdictions before that, mediation has been running into our veins and it's a part of our culture. Now, not only that it's a part of our culture, but fortunately, the legislature and the judiciary both have played a vital role in developing mediation as part of our decision-making process in India. The Parliament added Section 89 in the Code of Civil Procedure, but mere addition could not really work well. And all of you know, those particularly practicing India, that before the Supreme Court really interpreted that section in Salem Bar Association matter, which really give a brief and enforcing power to this provision, it was like a dead provision before that. Then came AFCON infrastructure judgment, M.R. Krishnamurti judgment. The court ventured into and really brought the provision of mediation from one field to another. It started in pre-mediation in the Code of Civil Procedure. It was simply to marital disputes.